I want to thank everyone for coming to today's community conversation. My name is Dave Zapponi. I'm the CEO of ECHO, otherwise known as the Educational Council of Homeowners. Thank you for participating in today's community conversation on privacy, cameras, recording. What can we do? ECHO is a 51-year-old statewide nonprofit association established to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connections. For today's event, we have a few housekeeping items. These are now presented on your screen. This slide deck was also sent to all registered attendees prior to today's webinar. Take a moment to review our housekeeping items. Today, we have a large audience of HOA homeowners, more than 240 registered attendees. We will do our best to answer all of your questions, but we may run out of time. Stephen will answer questions during the Q&A session. At the end of the webinar, we will answer as many questions as possible. In addition to the live Q&A session, I will answer some questions via text in the Q&A feature during the presentation. To prioritize your questions, please use the upvote button in the Q&A feature. These questions those questions with the most upvotes will be answered first. It's easy. Simply use the thumbs up in the bottom left corner of each question button to pick your favorite questions. Those questions with the most thumbs up will likely be chosen first. Also, please keep your questions general in nature and short. We may pass over some questions. Specific questions about your community are best asked of your attorney and another appropriate attorney familiar with your situation. Please use the chat feature to report technical issues and to communicate directly with other participants in the webinar. We do not monitor the chat conversations for questions. Now let me direct your attention to your monitor where you will find our disclaimer. None of what is said during this seminar shall be construed as specific legal or expert advice from the speakers, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert. The information we provide during this seminar is educational in nature and should not be relied upon for specific decision-making purposes. Thank you. This webinar, as well as all our events, are made possible by the generous support of ECHO HOA professional service providers. Join me in thanking today's program sponsor, CID Consortium LLC, and our registration sponsor, Levy Erlinger and Company LLC, CPAs, and the Collins Management Company. Connor, do you have a video to play?
HOA board members are volunteers from a variety of backgrounds who face complex legal, financial, social, and maintenance challenges. CID Consortium LLC is proud to support educational opportunities for volunteer board members and HOA members. At CID Consortium, our purpose is to enhance your community living experience.
Thank you to CID Consortium for supporting us today. Please support all ECHO professional members and especially our sponsors. They make our educational programming possible at little to no cost to you. And now a bit about our speaker today. Stephen T. Brindle, Esquire, is a senior associate at Swedelson Gottlieb Community Association Attorneys. He represents and provides corporate counsel to community associations on a wide range of matters, including covenant and rule enforcement, architectural rules, disability and fair housing, common area maintenance, elections, assessments, insurance, amendments and restatements of governing documents, contract review and drafting, and board and manager education. He also has real estate law experience regarding leasing and ground leases, retail, office, and industrial, escrow and title, boundaries and easements, and zoning matters. So at this time, I'd like to introduce Stephen, and please take it away.
Thank you, Dave. Thank you very much for having me here today. So this appears to be a very popular topic based on the registration today. I know that these types of issues come up a lot. Things having to do with privacy, cameras, what an HOA can and can't do. So we're going to talk about that today. On the next slide will be a little bit of an overview of the topics today. So today we're going to be talking about cameras, both owner installed and also association installed cameras, accessing the cameras, who can access them, who can't, providing access to the cameras to the police, whether owners can or should be able to record meetings, distinguishing a little bit between the difference between security and access control, which is the term that we prefer to use. Again, accessing the recordings, how long they should be kept, the new types of technologies available, and what to do if there's any kind of a crime in the community. I'm ready for the next slide, Connor. So, cameras. Can homeowners install cameras? Yes, it is legal for homeowners to install cameras. It's really not that different from if they were just to look through their peephole. A lot of this is going to have to do with sort of condominium buildings as opposed to planned developments, because there's probably more issues involved there. But yes, it is legal for homeowners to install cameras in a way that they are able to see outside the front door of their unit. So if this is going to, if it's within their unit, it's not an issue, usually. If it's outside of the unit, that can start to be a little bit more of an issue, because then you get into questions of, is this going to be affecting the common area? Are they going to have to drill into the walls that the association's responsible for maintaining? And particularly, where is their camera able to see? Generally speaking, if a homeowner is going to install a camera outside of their unit, like a Ring doorbell or something like that, we want to make sure that the area that they're able to see is just directly in front of their unit, and they're not looking into other people's units, and they're not able to see, a wide angle view of the common area, because that starts to present a question as to whether they are invading on people's privacy, right? So a good practice is to say that owners have to apply for permission from the HOA to install these types of cameras outside of their units, and then to make them record a covenant, which is something that gets recorded and then runs with the land, so that not only they but any future owner of that condominium unit are going to be responsible for maintaining that camera and agreeing to only use it according to certain rules. Again, if it's within their unit, not so much of an issue, but if it's outside in the hallway, then we want to start asking them to record a covenant. So when it comes to associations themselves installing cameras, they are able to install these types of cameras, but we want to make sure that, first of all, a good practice is to have a sign up that says there's a camera here, so that people know that it's there. And also that we want to avoid saying that these cameras are monitored 24/7. If you say that the camera is monitored 24/7, that strongly suggests that the HOA is actually actively viewing the footage from it, or someone with a third-party vendor is viewing that footage. So a good practice is not to have those types of signs up. I mean, I know that they sell them at hardware stores to say this area is under 24/7 surveillance, but to be honest, it's probably not, right? And so we don't want to say to people that we're monitoring this area 24/7 when we're actually not. When it comes to homeowners wanting to install cameras on their balconies, they're able to do that as well. But again, they're probably going to be having to drill into a common area wall to do that. So again, just like the hallway camera, a good practice is to have them sign a covenant, which your HOA's attorney can prepare, to say, we're giving you permission to install this camera here. but you agree to, repair any damage that it causes, to indemnify the association, that it's only going to capture certain areas. So a camera that's installed on a balcony or, a patio or something like that is probably going to be able to record more of an area than a camera that's installed in a hallway. So again, if you don't have any rules, then it's hard to enforce it, right? If your documents just don't say anything, and if you have older CC&Rs or older rules and regulations before these types of cameras were widely available, they're probably not going to say anything about it. But associations can adopt rules that regulate this type of thing through a camera policy, which many HOA attorneys are able to prepare. It's usually pretty short, 2 to 3 pages, but it says, here's the rules that govern homeowner installed cameras, and here's the rules that govern HOA installed cameras. When it comes to, sometimes a question comes up that what if we just install a dummy camera that doesn't do anything? And it's just there and people see it and they think that, well, if the camera's there, then I'm less likely to, or it's less likely that somebody might do something that would violate the rules, or it might deter crime in some way. The problem with dummy cameras is that eventually you're going to get a situation where something is going to happen, and somebody's going to say, I want to see the footage. And if you say, well, actually, it's just a dummy camera, it doesn't actually work. This actually happened up in the Bay Area a few years ago on BART, which is the public transit system there, where this news media had this expose on it, and it turns out none of the cameras actually worked, right? They were just there for deterrence, and that they didn't actually do anything. So instead of spending the time and money to install a dummy camera that doesn't do anything, you may as well just install an actual camera that does do something. Audio surveillance is treated a little bit differently from video surveillance. The kind of thing that we're really kind of concerned about is, where do people have a reasonable expectation of privacy, right? Obviously, if somebody's walking through the common areas, they can be seen by anyone else, even without a camera. So they don't necessarily have an expectation of privacy. But there are laws governing audio surveillance, which is that if it's okay for a camera to capture audio, but it can't use technology to enhance that type of listening, to the point that it can capture things that people are saying during a private conversation in a way that they wouldn't be able to be heard normally. So a lot of associations, the cameras don't even capture any audio. But if a homeowner installed or an HOA installed camera does capture audio, it can't use technology to enhance that listening experience and capture private conversations where people are having an expectation of privacy, because they would, normally lower their voices if they saw somebody walking by or something like that. There was a case a few years ago where a lot of you might know the comedian Kathy Griffin. She had issues with her next door neighbor in her homeowners association, who happened to be the CEO of KB Homes, which is a major developer. And she installed cameras in her backyard on her balcony that were able to capture some of the loud parties that this gentleman was having next door. And she used this video and audio that she recorded, she and her boyfriend, and she sent it to the board, and she said, this is an example of the types of parties that I'm hearing. And I guess during one of these parties, Mr. KB Homes got very angry at her and started yelling at her, and a whole spew of expletives. And she decided to use it as part of her act, right, as part of her comedy act. And then, of course, he sued, like any good American. And he had several different theories as to why he felt that his privacy had been invaded. But among them was that these cameras recordings were capturing things that couldn't normally be heard. And so the court looked at the whole situation. This went up to the Court of Appeals. There's a published opinion about it. And they said, no, these parties were so loud, and this gentleman was yelling at her to the point that the cameras weren't really using technology to record something that anybody couldn't just generally hear just standing on the balcony. So they said that that was not an invasion of privacy, either civil or criminal. So again, that just kind of goes to It's one thing for the camera to capture video. And if a homeowner installs the camera outside their unit, it should only capture the direct area in front of their unit. But if a homeowner installed or an HOA installed camera is also capturing audio, it cannot use technology to enhance that experience. It can only capture the same amount of audio that would normally be able to be heard in that situation. I'm ready for the next slide, Connor. So again, two kind of major concepts that we will kind of focus on when we're talking about cameras is there a reasonable expectation of privacy? Meaning that would the average person in this situation be expected to be seen? So a camera that somebody installs, either an owner or an HOA, cannot see into someone else's unit or home, even when they're opening the door just to go inside. That it's only capturing the direct area right in front, and that if they are going to be drilling into the balcony, drilling into the sides of the walls, drilling into the area outside of their door jamb, you can require them to submit an application for architectural review approval, because they are actually going to be affecting the common area. Some associations don't do that. They say this is such a minor modification that we don't want to go through the whole rigmarole of requiring somebody to submit an application. That's up to them, but just keep in mind that if someone's going to be drilling into the walls to install this types of camera, there's always a chance that it could short out and cause a fire, or impact the waterproofing of the building. So you can actually require these people to submit an application to do so. I'm ready for the next slide, Connor. So a lot of questions come up often about who has the right to access the recordings that the cameras make. So any recordings that that an association installs has are association records, but they're not records within the definition of the Davis-Sterling Act, to the point that anybody can just say, I want to see these recordings. The board has the right to review them because the board is in charge of the association, right? They manage the association's affairs, and the board generally has an absolute right to review any of these records. But just because a camera captures something and a homeowner asks to see that doesn't mean that it has to be provided to them. However, it is discoverable in litigation, right? Because it is one of these corporate records. So the same as any other type of documents, that's not protected by privilege, anything that the camera captures could potentially be discovered in litigation. So when a homeowner says, I want to see this record, or I want to see this footage, it's kind of up to the board how much that they want to provide to them. Some associations, they make these cameras available online on a 24/7 basis so that anybody can see them. I can see there being problems there. It could be a sort of a tool for mischief. Most associations only provide limited access to these records. So when someone says, my car was vandalized, or my unit was broken into, or my storage unit was broken into, the board may decide that they want to allow that person to see it. Many boards also will say, we'll only provide it if we get a police request or if we get a subpoena, because the concern is that how is this footage going to be used? Is the board going to, what is the member going to do with it? Another thing to keep in mind is that, because of data issues, recordings are generally not kept indefinitely. Unlike minutes where an association has to keep them forever. Most of these providers of these types of camera systems, they only store the footage for 30 days or something like that. And then it's automatically erased to provide room for more images. So it could be even shorter. And so if you're going to have a camera policy, it should probably say something about how long the footage is actually going to be kept, and that the board will make the footage available under certain limited circumstances if a member makes a legitimate request for it, or if they receive a subpoena, but then it's going to be automatically erased, so that people don't say, I want to see something that happened months ago, right? So where that footage might not be available anymore. So, just keep in mind that any footage, any audio, any video, any images that these cameras record, they are association records, assets, but the members do not have an automatic right to review this types of data. It's really up to the board how and when they want to allow it. Some associations also, if they, for example, I've had situations where an owner gets called to a hearing, and as part of the evidence of what they did wrong, they provide them with a video or an image of the person in the act. And so that's another way that these cameras can be used. It's not just to monitor crime, capture somebody committing a crime, but also capture somebody who's potentially violating the rules, right? Throwing stuff down the garbage chute and breaking it or something like that. So that's just another way these cameras can also be used. I'm ready for the next slide, Connor. So, should we record meetings? No, but many associations do. But a general practice is that it's not good to record these meetings. Homeowners association meetings are not public meetings. The owners have the right to attend the open session meetings, but to watch the board in action. But no one who's not a member of the association has the right to attend them. That includes owners' attorneys. And so boards can adopt rules that say there can be no recordings of these meetings. The Homeowners Association Open Meeting Act, which we refer to a lot, was modeled on the Brown Act, which is a act that has to do with meetings of governments and other types of public entities, city councils. That actually says that anybody attending that meeting has the right to record it, right? The fact that the legislature did not say the same thing about homeowners association meetings is instructive, because it tends to show that the legislature did not actually want to create that type of right. So neither the individual board members nor the attendees have a right to record those meetings. Boards can adopt rules that say there can be no recordings of these meetings, and that anybody who is recording it is going to be removed from the meeting. The problem with recording, it doesn't seem maybe on the surface to be an issue, is that first of all, it tends to chill speech. When people think that anything that they might say during homeowner forum, or the board members might say when they're managing the association's affairs, might be used against them later. Here's Exhibit A. Or that it could be put on YouTube or something like that. Look at this board, look what they're doing. Generally speaking, when somebody records a meeting, it's not for a good purpose. It's because they want to embarrass somebody or embarrass the board, and so it's generally not a good practice. People might say, like, well, what about my First Amendment rights? The First Amendment doesn't really apply in this situation. The First Amendment says that Congress shall pass no law, regarding free speech. But this isn't Congress. This is a homeowners association. So, generally speaking, not a good practice. You can put in the agenda, some of the rules for the meeting and say that there can be no recording here, and then just go from there. I'm ready for the next slide, Connor. Okay. Access control. Why do we say access control as opposed to security? Homeowners associations, their main job is to maintain the common area and to manage the association's affairs. They are not legally required to provide security to the residents. What we want to avoid is creating a duty that doesn't already exist at law. So, to say that a homeowners association provides security is a huge liability, because HOAs generally don't have the legal capacity or the funds to ensure that nobody who lives in the community is ever going to be the victim of crime. That would make their insurance premiums skyrocket. It would be way more expensive, and it's just generally not within the scope of what an HOA is formed to do. So we attorneys, most of the attorneys that I work with, and at other firms as well, what we generally refer to is what's called access control. What we're saying, security is protecting a person or property against crime or the threat of a crime. Access control is a system where personnel determine who is and is not entitled to get into the community. So a lot of associations, they either have somebody on their staff or they partner with a third-party vendor who provides this type of access control, who monitors who's coming in and out of the community into the building, or et cetera. And so, but even those access control people are generally going to say in their contract that they're not responsible for protecting the residents and the property from crime. They're not guaranteeing that there's never going to be crime, right? It would just be too much liability for them. We would always, of course, try to get them to say something to the effect of, what they will and won't do, the hours that they're going to be working, what their job description is going to be. But associations, they're not providing security. A lot of them think that they are. A lot of the residents think that they are. And so when a crime happens, they will say, why didn't the HOA do something to protect me here? I thought that's what I'm paying my assessments for. Well, actually, you're paying your assessments to maintain the common areas. You're not paying assessments to guarantee that there will never be crime in the community, because that's just not realistic, right? The association cannot make that type of a guarantee. They can't protect the entire community from outside crime. They can do what they can within their articles of incorporation and with the funds that they have, but they're not ever really guaranteeing that there's never going to be crime in the community. So be careful about saying that you're providing security or safety. Really, you're not. If you want to, you can have a system of access control, either that you yourselves do or that you partner with a third-party vendor. But you don't want to be creating, again, a duty that you don't already have at law and exposing the association to liability. You do have an obligation to notify residents when you are aware of crime. So there's a famous case called the Francis T case, where this woman was complaining about crime in the community, and she wanted to install a camera outside of her unit, and they and some additional lights. Sorry, not a camera, but some additional lighting, and they wouldn't allow her to, even though they were aware that these issues were going on. And then later, she was the victim of a crime herself, and she went to hold the HOA accountable or liable. And the court said because the HOA was aware of these issues and they didn't allow her to do this, they could potentially be liable, right? So because an HOA has the same sort of obligation to maintain the common area as, say, like a landlord does. So that means notifying people of crime when you're aware of it so that they can take proper precautions, which that might include installing additional lighting or installing a camera or something like that, but not to the extent of we are going to guarantee that no one ever experiences crime in this community, because that's just not realistic. I'm ready for the next slide, Connor. Let's see, which one are we on? Oh, there we go. Oh, yeah. It seems to come up a lot about using cameras around the pool areas. Again, that's the common area. The association can install cameras there. But again, the overriding concern is always, is there a reasonable expectation of privacy here, right? What is the reason that you would be wanting to install cameras in these areas? Is it because we've had an issue with intruders coming into the area, into the common area, using our pool who don't actually live there? That might be a valid reason for using the cameras, to see if somebody might be coming in through the door or over the fence or something like that, but not to the extent that we can actually record people in their bathing suits in the pools. So the cameras are either for one of two reasons: to deter crime or capture evidence of a crime, or to capture evidence of some sort of a violation of the governing documents that we can then use if we have to call somebody to a hearing, or just tell them, hey, we saw you, and again, the cameras are not monitored 24/7. If the board receives a report that some sort of a issue has happened, whether that's a crime or a violation, then they go back and review the camera footage. But not that they're always reviewing it, they're always looking at it. At any hour of the day, they can log on and see what's happening at the pool, or see what's happening in the hallways. It's that they received a report and then they went back to look at it, and then they found what actually happened. So it can be to discourage crime, and it can also be to discourage or record evidence of the violations of the governing documents, right? So generally speaking, the associations that do install cameras, they install that at the entrances to the property, in the common areas, but not to the extent that they're ever going to be invading somebody's privacy, or somewhere where they have a reasonable expectation of privacy. I think we'll go to the next slide. So cameras, there's new technology available now that actually can record. It can sort of create like a dossier of someone, like a profile. If you get a report that somebody has been coming in and they're an intruder, and it uses this technology to develop a system where it can say, anytime we get a report that this person has been on the property again, we want to be notified, right? So it's not that you don't ever want to program it to say we want somebody with this particular description ahead of time. It's that after it's recorded someone, then it goes back, and then you can say, anytime you see this person again, based on facial symmetry, we want to be notified of it, right? So it uses AI. So you're not programming it ahead of time, it's after the fact. But it's a useful technology. Some of these newer vendors are using these to, it enhances the ability of the system as opposed to just sort of passively recording what's happening. It can actually, be used to program to say, notify us when you see this person again, if you've had an issue with someone coming in on a regular basis. So you don't want to program it ahead of time because there's concerns about profiling, but it's for individuals who come into the community. Next slide. So can the association be held liable if there's a crime in the community? I guess a better question is, will someone try to hold the association liable? The answer is yes. Often people are just looking for the deepest pockets they can find when there's a crime, particularly when they are not carrying enough insurance. So if somebody breaks into the building and they go into somebody's storage locker and they clear it out, there's a pretty good chance they're going to try to hold the HOA liable. At which point, you'd have to be having your insurance involved. But that's why it's important to say, we are not responsible for security. We will do what we can to try to control access. We will do what we can to notify you when we're aware of any kind of a crime happening so that you can take proper precautions, which includes carrying automobile insurance, carrying homeowners insurance, carrying insurance on the items in your storage locker. But we cannot guarantee that there's never going to be crime, because that's something that's outside of our control, right? So unless you were negligent in some way, like somebody says, hey, I want to install, negligence is a very fact-specific inquiry, but an association is not automatically going to be liable for crime just because it happens. So that's why it's important to have these types of notifications go out to tell people so that they can take proper precautions themselves, but also gently reminding them, we'll do what we can, but we cannot guarantee that there will never be crime here. Is a crime watch committee or a neighborhood watch a good idea? It sort of depends. If the purpose of the committee is to monitor things that are happening and let the management company know, or let the board know, send out reminders every once in a while to tell people, there was a report of XYZ, you should take proper precautions, that's probably okay. But it's more of an issue when those people try to take the law in their own hands, right? To use a famous example of this case out of Florida with the Trayvon Martin, there was this gentleman, George Zimmerman, who was wandering around the community with a loaded gun. And then the HOA was actually publishing in the newsletter, he's our night watchman, right? And if you have any concerns, you should let him know. He actually wasn't even a homeowner, and I don't think he was even on the payroll. He was someone, he wanted to be a police officer, right? And so this is how he thought he could get into the field, was by patrolling the community and personally confronting people who he thought looked out of place, right? And I think we all know what happened there. So is a crime watch committee or a neighborhood watch a good idea? As that was the initial question. If the purpose is to notify the residents when there's crime, or to let the board know, or to let the management company know, that's fine. If the purpose is to confront people who they themselves determine to be not appropriate to be in the community, that's a problem. So if you're going to have any type of those committees, that's how you really want to structure them, and that'll all be in the resolution that the board adopts when they create those. So, and should your community have a camera policy? I think the answer is yes. If your CC&Rs and rules don't already say anything about cameras, which if they're older, they probably don't, then you can ask your attorney to adopt a camera policy that says, here's where the association's cameras are going to be. Here's how long they're going to be keeping the footage. Here's the type of footage that they're going to be recording, that they're not a guarantee against crime, that owners do not have a right to review this footage unless the board allows them to see it, or unless they receive a subpoena for it, and that it will, or the police ask to see it, and what the purpose of them is going to be, and when it comes to homeowners cameras, where they can be installed, what type of footage they're going to record, and that they cannot view into anyone else's unit or separate interest or home. And so if you don't already have any rules, then it's just silent, right? Somebody can just kind of do what they want. So a general good practice is to have these types of policies in place so that when you get a request, you already have rules that govern it. And I think that is the presentation. Connor, next slide. So now we're at the Q&A session.
Great. Thank you, Stephen. Lots of really good questions here for you. So I want to say thank you to our Q&A sponsor today. And I want to give you a make sure that everyone uses their thumbs up icon to ask any questions that they might have, and vote for your favorite questions. We'll go ahead and start with that. Take a few seconds to do that. And let's go ahead and start with, do this real quick. Gary has a question about a condo owners. Many condo owners have installed Ring cameras without submitting an architectural change request. What should the board do about that?
So is this on the open question? I thought we were going by a upvote system, or?
Yeah, so if you go ahead and open the Q&A, Stephen, and then in the upper right, do most upvotes, and then that should move his question.
Oh, I see. Top. Okay. So this is Gary's question?
Yes, Gary's question.
Okay. Many condo owners, Ring cameras without submitting an architectural change request. So yes, technically speaking, if they've done something in the common area without submitting a request or without approval, then you can remove it. But chances are, if they did submit a request, you probably would have approved it anyway. So unless it's presenting a real issue, to the point that it's impacting the common area, the better practice is to adopt some sort of a policy that says, going forward, any new requests are going to have to be submitted. You have to submit an application for it. Otherwise, you're going to have to be going back with every single person who installed a Ring camera, which is a lot of people these days, and saying that they have to remove them and then resubmit them, even though you're probably going to approve it anyway. So hopefully that helps answer his questions. Unless, Dave, you think that there's something else that he's asking?
No, I think that sounds good. And Gary, if you need more, let us know. Just send another note in Q&A. for clarification. Jeremy asks, if our HOA has an automatic license plate reader, can the board adopt a policy that prohibits directors from viewing the data? Let's take that one first.
Okay. Adopt a policy that prohibits the directors from viewing the data.
Correct.
So yeah, Jeremy cites Corporations Code, which is good. That's a statute that I refer to often that says the directors have the absolute right to review records. It's probably better to have the management company to be the one who has the first right of access to this information. Most directors will use it appropriately, but we can't have a situation where directors are using these records, using the information that the automatic license plate readers are taking, and then deciding themselves what they want to do with that. If the management company is the one point of contact that sees this, then it can decide whether there's something that needs to be done here, whether we need to notify the police, whether we need to get a warning every time that this person comes into the community, whether an owner needs to be called to a hearing because of their tenants' potential violations of the governing documents. But I think it's a best practice. It's better for if you have a management company, I think it's better for them to be the ones who have access to it as opposed to the directors. Yes, directors do have an absolute right to review records, but there can be situations where a director could be conflicted, or that we may not want to allow them to see these records, or that we may need to condition viewing those records because of a director's conflict. So yeah, I think it's better to, certainly that's the back practice. Could such a policy be enforced? Yes, I think it could be enforced.
Okay, sounds good. So we appreciate that. Regarding the license plate readers, do you need to put a sign up that indicates that you are reading their license plates as they go by?
I don't think you need to, because anytime somebody has, they do not have a reasonable expectation of privacy, you don't necessarily need to tell them that. But it is a good practice when you have cameras in the common areas, or whether you have cameras that, can read license plates, to say, there's cameras here. They're not being monitored 24/7, but there are cameras, so that somebody can't say, well, I didn't know, this was an invasion of my privacy, the fact that I recorded this. So more transparency is always better. But I'm not aware of any legal requirement where you have to notify people of it.
Okay. I'm curious to know, and it speaks a little bit to iPad's question here. How do you determine reasonable expectation? She asks, or iPad asks, may a homeowner use a camera facing the common area and other homeowners' private patios? What's the standard that's applied there for a reasonable expectation?
So if it's the common area, it's not too much of an issue. Right. Unless they're using those cameras to record every single person walking through the main parts of the community, and then saying, like, I saw so-and-so doing XYZ. If they're seeing into somebody's private patio, though, that's definitely a problem. Reasonable expectation of privacy, this is actually a term that comes from criminal law, but they use it in this context as well. It's where a reasonable person would not be expected to be seen or heard, right? So if it's somebody's private patio, going back to the Kathy Griffin case, she put the camera on her balcony. It didn't see into her neighbor's backyard, but his parties were so loud, and he was yelling at her so loudly that she was able to record that without any kind of special technology, right? So the court there said that is not an invasion of privacy, because a reasonable person would be expected to be heard by their neighbors in that sort of situation, right? So that's what they mean about reasonable expectation of privacy. So putting a camera that records people in the common areas, question is obviously, like, why are you recording people in the common areas, right? Like, why not just the person who comes to the front door of your home? Why do you need to see somebody who's walking through the main parts of the community? But it's where a reasonably sensitive person would not believe that they are being seen or heard.
Okay, so on a golf course, if you're on the 13th, green, and you have a patio and a pool and a low hedge, small, maybe a wire fence or something, just separating you from the fairway, or maybe no fence. But it is private property and is a patio, and your buddy's taking a picture of you, swinging that club. Is that a reasonable expectation or privacy or not? Because you put it there in clear view.
To record the people on the golf course.
Yeah, right.
I mean, if it's the common area, that goes toward they're not having an expectation of privacy.
Right.
But it's also like
the private area where if your patio backs up to the golf course and you're on the 12th green or something at the tee box, and you can see them and you're intent on seeing the people hit the golf, you like the view, whatever the reason, and they of course can see back and they can maybe take pictures of the guy taking a swing, and whatever. That seems to me to be not a reasonable expectation of privacy because it's in open view. Is that a fair assessment of how that standard might work or might not work?
As a non-golfer, trying to envision what this situation looks like, if it's incidental to the recording of your own backyard, then yeah, I think there's less of an argument there that just because you happen to see someone on the 13th hole or whatever, they don't have an expectation of privacy. But if you're using technology to enhance your own natural vision and hearing to record these people, then you're potentially starting to go into the area where you are invading somebody's privacy.
So it goes maybe to motive too, then, right? I would assume.
It could potentially, yeah.
Okay, and so there was an interesting question that was in the box that was about putting a ring in a condo that has hallways. So put the ring up so they can see who's coming to the door, and everybody's trying to get into the door. Especially now that you have smart technology, so you can see it from wherever you are in the world. But it also took a picture. You could also see the inside of your neighbor's house because the door directly across was your neighbor's, and when they opened the door, you could see in their house. They know that. Is that a reasonable expectation that room is something that you would see or not?
So this is kind of a fact-specific question. I think I would have to actually see the picture of what is being captured here. Okay. But is this the anonymous attendees question?
Yeah.
Okay. I have a video camera outside my front door into the common area. I can't help but have it aimed towards my neighbor's front door, and they've recently demanded that I take it down. I think I would have to see that. I think I would have to see that footage, but I think as a general best practice, we want to say that it can only capture the direct area outside your front door and not into other people's units. Sometimes incidentally that it might capture that. But yeah, I can see how this can be an issue because people are going to be concerned that every time they open the door, their neighbor is going to be recording inside of their home, right? So I think I would have to actually see that to answer that.
So the bottom line here, Steve, just to get you kind of off the hook here, it really depends on the situation and that reasonable expectation. You'll need to defend yourself that is a reasonable expectation. They don't have to defend themselves necessarily that it's that because it's looking inside their house and the house is considered private area. So for most people, and it wasn't anonymous, it was someone else that wrote the question. We had several of them in a row that were very similar to that. So with somebody who has a camera that incidentally looks into somebody's expected private area, you're going to have to be very careful about that because from what I'm hearing is that they could make you pull down your cameras. That could be a violation. So you just have to be careful, and it is going to be fact specific And so watch it and be careful. It's best not to try to look inside somebody's windows. I've always felt that it was, if the area, was open and, like the bay windows in a home or the patio, there wouldn't be a reasonable expectation, because it's open, they're looking out, anyone could look in and out, so that makes sense. But if it was the bathroom or bedroom or some other
Oh
part
yeah,
of
absolutely, absolutely not.
that,
You would never want a camera that can actually see into someone's home for any reason. It's one thing to have a camera that's directly outside your door to see who's coming to your property, but you definitely don't want to have anybody. I mean, that's just a nuisance, right? Like that not only is that potentially illegal, but if you're using technology to see into someone's home, that's you're eavesdropping or spying, which could potentially be a nuisance, right? So
okay, so
if you have any kind of a policy about cameras, you have to say that like that you cannot use them to see into someone else's home.
yeah, so the advice for those listeners is to make sure that if you want to be 100% certain that it's not going to be a problem, make sure that you don't even incidentally look into somebody's window or any other private areas. Make sure that it is common area, because common areas is allowed, but not into somebody's house. Now, there is a little bit of a gray area is what I'm hearing, because maybe there is, like the patio on the fairway, that's a potential, there you could make an argument, but you are walking into a gray zone and you're going to have to defend yourself. So you need to decide whether that's appropriate or not, or the community does, whatever those standards are. So let's go ahead and
Right.
move on.
Okay.
All right. Can a member of the HOA record with a mobile phone all the parts of an open meeting? For example, the board of directors meeting, open all of the parts of, so they go you have a homeowner that goes into a board meeting and they have their phone, they put it on record. Can they do that for the entire meeting?
So the law in California is that all of the participants to a private conversation have to consent to allowing it to be recorded,
Right.
which would mean all the directors, everybody who's attending the meeting, who's speaking during homeowner forum. So you do not have a right to record these meetings, and the best practice is to have something in the agenda for the meeting that says recordings are not allowed. I've been in these meetings, particularly where there's a contentious issues with the board, or there's a recall or something like that, and I see somebody holding their phone up to us, right? And they're, I'm recording you, and they're usually doing it because they want to use it against the board or the HOA in general. But if you don't have any kind of a rule about that, then it's kind of an open question, right? So best practice is to have something in the agenda that, among the other parts of the agenda that say, here's how long homeowner forum is, here's how many minutes people get to speak during the homeowner forum, no obscene language or insults or threats or anything like that, but also recordings of the meeting are not allowed, right? So if you don't have anything about it, then it's not clear. So I don't think that's the type of rule that has to go out for like member comment and review, because that has to do with the board's own meetings, right? So the board can adopt reasonable rules regarding its own meetings that's not the type of operating rule that the Davis Sterling Act requires that people send out for everyone to comment on it. I think that they can just adopt that.
Mm-hmm. Well, and anything that's recorded is discoverable. So that means
Right.
that attorneys, if there's any lawsuit, they can ask for those recordings,
Right.
even if the reason you recorded it had nothing to do with the factual, the matter at hand
Right.
you're being sued about. And so you just don't want to necessarily have that, because you might have something else on that phone that you don't want people to be seeing or whatever. You might not want to give up your phone for, a few days, so that it has to be part of evidence. So be careful about that one. And I think it's wise advice and probably best practice is to have a rule that says, you can't record. And remember, there is a California state law that says you can't record unless you have each person's approval. And I would say
unless they do not have an expectation of privacy. But yeah,
correct.
generally in a private conversation, California is what they call like a two-party state, although there could be more than two parties, where everybody who's on a conversation has to be consenting to that recording of that conversation.
So that's really good advice. And by the way, I'm not an attorney, just for the record. So Stephen's our attorney. So Carol Lawrence, Carol, I'm not sure I understand this question 100%, but 17 people seem to have. Some people in HOAs want a log on when cameras are accessed, accessed, I assume, and by whom?
I think what this is meaning is she wants a log of the people who accessed the recording. So a running log of who viewed the recording.
Okay.
Is how I read that question.
Okay. So, I mean, kind of going back to the presentation, the cameras and the footage and the video and the audio that they capture, those are association records, but they're not the type of records that the members have a right to see and review under the Davis-Sterling Act. So it's really up to the board when to allow non-board members to see that information. And the homeowners do not have a right to see it. Some people in HOA want a log. I mean, who are the people? Are we talking about the members? Like, there may be internal systems that these vendors use to say when the footage was accessed, but it's not the type of thing that I would probably want non-board members to be seeing, because it could just be used for all sorts of reasons.
Yeah. So one of the things, and I'm a board member too, and one of the things we really are challenged by is the enabling people in the community to be bad actors, to create discord or discontent in the community. So yeah, reasonably sharp about making sure you're fair and you're transparent, but that you don't that you're not enabling bad actors, bad behavior. So
right. I mean, like, going to that point, like one of the questions was like, should the board members not be allowed to view this footage, or should it go to management first? I think it's better for it to go to management first, as opposed to each individual volunteer board member who might be using this footage for a different reason, having 24/7 access to it. But definitely, I can see a potential for abuse if the members are saying, "Oh, I looked at the camera and I saw so and so doing XYZ, right? And I demand that the board do something about it." It's really not something that we want the members themselves to be accessing, if we can avoid it.
Okay, so I've got another question here from Anonymous, and I think you've covered this in the presentation, but a little bit. We'll just do it one more time here. Cameras in the pool area, can you use those? And the pool area would be, I presume, common area. Can you use those to pick up violations? And is this acceptable? Is it a good practice?
Is it acceptable? Yeah, it's acceptable. Like, let's say you get a report that somebody had glass at the, you found broken glass at the pool, and maybe somebody even cut themselves. And then you go back and you say, well, how did that glass get there? Because we don't really know. We just know that there was broken glass there. So then you review the footage, and then you find, oh, this person had a party and they had a bunch of glass at the pool. So then you can call the person to a hearing for violating the rules. But again, that's sort of like an after the fact use of the cameras, as opposed to like the board monitoring the cameras on a 24/7 basis and watching who's coming in and out of the pool. So it's when the board gets a report of something after, then looking at the footage and using that to back up what they're going to do with that. So, if you're going to have a camera at the pool, you would want to have a sign up that says there's cameras here, and let people, and in your camera policy, say, but the cameras are not monitored 24/7. They're only being used for if we get a report of a crime or to investigate any kind of a violation of the rules. And so that's going to be used after the fact. Does that sort of answer? Do you think that answers her question, his or her?
I think it does.
Okay.
Now, Lynn is asking a little different question. So, and I'm going to paraphrase this a little bit, make it, so if a member goes to the architectural committee, a review committee, and says, I want to have a camera, I want to make sure that this is legit, And so she fills out the paperwork and sends it in to the Architectural Review Committee. But the review committee does nothing. They sit on it because for whatever reason, they don't respond. So what is the next step? And she's talking, she mentions an IDR. I think probably the next step would be to go to the board in a board meeting and talk to the board and say, hey, look at the ARC didn't take a look at this.
This is a fact specific question. And it's going to depend on what the CCNR say as far as how long the architectural committee has to review applications.
Right.
So, you know, I think this is kind of asking for a specific legal answer as to what needs to happen here. You know, you'd have to look at the governing documents. We try to draft them in a way where we say if the architectural committee doesn't do anything, that that's deemed denied as opposed to like deemed approved, because that puts the association in a better position. But you know, if you're concerned and you're not sure whether you're able to move forward or not, IDR never hurts, right? It's always good for people to get together and talk this stuff through. But I think this is kind of a fact specific inquiry.
Yeah, and I think from my perspective of being a board member and not having a legal background, I think I would talk to the ARC and ask them why, just downright ask what's going on here with our application. If they don't have an answer, you can't reach them, then you know, talk to a board member, talk to the board itself. It's sometimes we get a little too legalistic, and what we need to do is act more like neighbors and talk to each other. And maybe it fell between the cracks. I mean, literally could have fallen between the cracks. And then, you know, if you need to go to the ARC, you know, go to the docs and you know, read them, make sure you follow the documents and how you process a grievance. I mean, that's completely legit. But I think my first inclination as the vice president of my board would be, I'd want a neighbor to knock on my door and say, hey, look at this, is happening. And then I'd say, oh, let me check and see what's going on there and get an answer back.
Right.
The biggest
that's excellent advice.
One of the biggest problems we have is failure to communicate in our communities. You know, there's a big apathy there, but the boards have got to be able to communicate back to the community as well. That's what generates, you know, a good dialogue with the community to make sure things are being done right. And unfortunately, it's not done enough. So enough of my soapbox. Can an HOA prohibit homeowners from installing cameras in a PUD, a planned unit development?
If it's a planned unit development, first of all, PUDs are actually different from planned developments, but I assume that they're talking about a planned development.
She said planned unit development, so
okay,
but she might not understand that. So
prohibit homeowners from installing cameras in a PUD. It depends on what the CCNR say as far as what type of rules the association can adopt regarding people's property. Many of them will only allow the association to, you know, adopt rules regarding the common areas, unless it's something that is happening on a single person's lot that affects the common area. But I think the answer is it depends. They could potentially, because like a lot of them will say, you know, a lot cannot be used for commercial purposes. It can't be rented out on Airbnb or something like that. Whether they could adopt a rule that says no cameras can be installed kind of depends on the powers of the association. So I think that one also kind of is going to be fact specific.
Okay, and then anonymous in the next question here. The board member neighbor has the surveillance pointed in my unit, violation of the architectural rules, AR, I assume is that as well. How can I get this removed? That's a process of, and I think this is one of those that you're going to want to follow the, you know, get your governing
call your attorney,
yeah.
or ask the maybe the board should call the attorney.
Yeah, the board should call the attorney. That's the way to do it. But if they don't, you do have recourse. But this will depend a lot on what the facts are. So your specifics. Let's go.
I do want to address Ed's question at the top.
Yeah.
Can the secretary record the board meetings to assist in the writing of the minutes? Yes, but then they should delete the recording, because again, the recordings are an association record. They're not a record that the members have the right to review, but they could be subpoenaed in litigation. So if the purpose of of recording the meeting is just to help them prepare accurate, complete minutes, they can do that, but then they should delete it afterwards.
Yeah, we get that question a lot, so thank you for that one. And as people and as communities are getting older, it's I think more people are leaning on recording and then making sure it's done. So Bobby Lee also has the same question. It doesn't reference who. Can we force homeowners to turn on privacy blocks, blocking the view? And I assume the HOA get into the programming of these cameras?
I think that that's within the scope of what an HOA can govern, particularly in a condominium building where they're installing it in the common areas to begin with. Can we require the audio be turned off? We do get those kind of questions sometimes where people, for whatever reason, have a camera pointing outside of their home through their window that's recording people's conversations. Again, I think it's going to depend on whether it's a condominium building, where I think the answer would probably be yes, or whether it's a planned development, where I think the question would be a little bit murkier. But you do want to have a policy that says if it's going to record any audio, it can't be more than what a normal person listening to that conversation could have heard.
Okay, and then James, you asked the question, what if the Ring doorbell views directly into the unit's window? I think we answered that one.
Right.
And these are really good questions. The important thing about blocking and privacy blocking and all that, and about any of your rules, is to make sure you apply them fairly across the board. Make sure
equally against everyone.
To everyone, or you're going to run into some problems there.
Right.
Bobby Lee, can we require that audio be turned off on the doorbell cameras? We just answered.
I think we just discussed that one.
All right, let me go to the top here again. Yeah, that one is gone. Can managers record a board meeting? Can the managers record the board meeting? I assume if the board is okay with that, they can record it.
Well, yeah, I mean, you would want the board's permission, but again, you'd want to say that the only reason that we're recording this is to assist in the preparation of the minutes, and that afterwards we're going to delete it. You definitely don't want to record something that's an executive session, because those are confidential, and they're protected by the attorney-client privilege. They can be discovered in litigation, but the homeowners don't have the right to review those. If you're having any kind of a disciplinary hearing, I would not want that to be recorded. I would not consent to it being recorded. The only reason anybody should be recording any meeting should be just so that to help prepare the minutes afterwards, and then the recording should be deleted.
Yeah. So anonymous attendee here asks about IDRs and
right,
recording the IDR and having access to the IDRs, because it seems like in this one I'm inferring, but that what if the person recording doesn't give the recording to the other side? So this is problematic, I think, right?
Right, I think so.
Okay, let's go on up. Let's see, Connor, we answered James's, and we're at George's. Hey, George, our condo units are configured so that each unit door faces the door to the other unit. When one door is open, the neighbor opposites can see the unit through the peephole, or with a camera mounted on or by the door. Does this mean owners are prohibited from having the benefit of such cameras? So I don't know.
I think we're getting a lot of kind of fact-specific situations here that I would. But if it's something that people could just see through their peephole themselves,
right,
less of an issue. If the camera, because you're not recording anything that you wouldn't normally just be able to see. The issue comes up when is the technology allowing people to see or hear something that they wouldn't otherwise, because then you are starting to get into the area of an invasion of privacy, because where somebody has a reasonable expectation of having it. So I think I'd have to see the footage, but always the question's always going to be, is this something that people could normally see, or is the camera allowing them to see something and or hear something they wouldn't otherwise?
Mhm. Okay, so let's go. And I think we have a lot of those that are now becoming fact-based and very similar to solve a particular problem that an individual may have that's viewing today. But I'm going to jump down anonymous Atadio ring. Okay, that's a comment. Fran's iPad. We have had very important hybrid Zoom and in-person meetings where owners on Zoom cannot hear well 50% of the audio, including the managers and important committee reports. And the documents are shown where the presenter says the owner can take a screenshot, but then scrolls through the documents so it cannot possibly be seen. The minutes are scant. What is required? So this is more about a meetings management and the new law on meetings. Can you speak to that, Stephen?
Yeah, so I think there is a law. You don't have to allow for hybrid meetings to begin with. You can still have them in person or entirely via Zoom. But I think that if you are going to have I'm looking at the statute right now, for if the association is going to have a video meeting, all the votes have to be done by roll call of the directors, and any person who's entitled to participate has to be given the option of participating via telephone. So, and you also have to have clear technical instructions on how to participate. Just the purpose of the meetings even being open to begin with is because the homeowners have a right to see what the board is doing, particularly with their money. So I would say that let your management company know, let the board know that I'm going to these meetings. I'm not trying to record them. I'm not trying to see, or I'm not trying to capture anything. But I'm having trouble viewing them because there's an audio problem, or there's problems with the cameras, and let them know. The minutes are scant. I mean, that's more of a question as to what kind of detail you're supposed to have in the minutes, which is kind of a separate presentation. But let the management company know, like, I'm a concerned homeowner. I'm attending these meetings and I'm having trouble really seeing what's happening there. And I'd like you to address that.
Yeah, that's good. Yeah, I think when we talk about meetings, a lot of times, with technology and all, you really do need to make sure that the information is available to all participants, all the homeowners. That's I believe embedded in that law. If not per se, it definitely is the intent. And also one of the things that we're finding is that you should have technical support for those people that aren't that good with technology, like me. And
Mhm.
you need, and they're trying to get in and they're having problems. You should have somebody that can help them, and I think you're supposed to have somebody that can help them access the meetings if they want to go to, and they have a right to go to the meetings. And
Mhm.
one thing that I know that Echo does do, if you're a member of Echo, we do provide technical support for Zoom meetings and online meetings. So if you're having a problem like that and you need some help, let us know. Don't ask me, ask Connor, because Connor's the one that does it. And he has been and is on a call for several different HOAs around the state to help them. Most of the HOAs that we've assisted in this regard, or that he's assisted in this regard, have we've been weaned after a few meetings, and so they get it,
Mhm.
and so finally we train them and then they keep going. But that's one of the benefits of being an Echo member.
Yeah, I mean, the statute that says that, I mean, first of all, it was an open question whether they could even still have virtual meetings after the quote unquote pandemic was over. No, I'm not calling it a so-called pandemic. I'm saying that it's not clear when it was actually over. But that the meeting notice has to have clear technical instructions on how to participate, and a telephone and an email address of a person who can provide technical assistance both during and before the meeting. So the legislature's intent is to say, yes, boards can still meet virtually, but there has to be somebody available to help them if people are having trouble, if the members are having trouble accessing the meetings, because otherwise they're being deprived of their right to see what the board is doing, right? So that you have to have that in the meeting notice.
Okay, well, here's kind of an interesting question. It says, on balance, does the HOA having cameras in a common area increase the HOA's liability or decrease it? Because on the one hand, you're increasing liability because of the privacy issues, but on the other hand, you might be reducing crime. What's your thought on that?
I think the cameras generally are going to have some sort of they're intended to have some sort of a deterrent effect on crime, right? As far as liability is concerned, again, the HOA is not by law liable for any outside crime or even crime that happens in the community. But when they're aware of crime, they're supposed to let the people know about it so that they can take their own proper precautions, whether that's applying to install a doorbell camera or beefing up their homeowner's insurance or carrying protective things with them at night or something like that. But I'm not aware of cameras increasing their liability. But you do want to say, like, area subject to surveillance, but not, and when in your camera policy say they're not being monitored 24/7, right? Because then you are creating a duty, or at least an expectation on the part of the residents that you're doing what you can to make sure that crime doesn't happen to them, right? Which is not what you're really doing. You're using the cameras for a deterrent effect to investigate a crime when it happens and to investigate when you get a report of a violation, but not for somebody to be, I mean, if you have the resources and you want to pay a vendor to monitor the cameras 24/7, I guess that's different. But I'm not aware of it increasing their liability, as long as you're clear about what the cameras are being used for.
Okay, that sounds good. It's an interesting question. I think we'll let that one go at that. Okay, anonymous. The audio on my neighbor's ring is always on. Okay, so that's just a comment. We can remove that one, Connor. Bonnie Cohen, my condo neighbor installed a Ring camera within her exclusive use garage that faces and records activity on the common area stairs to the garage and basement. I am recorded every time I take out my garbage. Is this, is this kind of an acceptable?
Fact specific, or
It seems pretty fact specific here, but
yeah, I mean, I can't say to any of the sort of hypotheticals, yes, that's okay, or no, that's not okay. What I can say is sort of like general best practices, which is that if you're going to allow somebody to install a camera outside of their unit, that it only captures the area directly in front. The same as if they were looking through the peephole of their door, right? Because otherwise you're using technology to enhance your own vision. But as far as whether this particular camera in this particular HOA is okay or not, I think I would have to see it.
Okay. It's important that you understand that Stephen doesn't have the specifics of all these things, and it is very difficult to come up with a solution and a black and white. This isn't black and white. This is something that is, this whole area has to do with sort of the gray. Where are we in the gray? There's some things that are absolute, but very few. On privacy, the management firm for my HOA provides private security as one of its services, who patrols our HOA and also responds to service calls. The management company used to share monthly security reports with us on a board with all the service calls, incidents listed, but recently stopped doing this because of privacy. As a board director, can we make them provide these records? Could California Corporations Code 8334 apply, giving the right of the directors to inspect the records?
Um, Well, I mean, it depends on whether these records belong to the association or whether they belong to the management company, right? Because the management company might have its own internal records that the board doesn't have the right to see. If it's a corporate record, then the directors potentially might have a right to review it. But one thing that kind of stands out about this question is that they say that they're providing private security. Again, we talked about this during the presentation. We don't want to use the word security or safety because those are things that the HOA and the management company are not actually legally required to provide. And we don't want to create a duty that they don't already have. We want to call it access control. But whether they would be required to allow you to review it, I think it would kind of depend on what your contract says, with the management company, as far as what the scope of their services and what are your records and what are their records. I don't see too many situations where a management company won't provide its own, the records that it creates on behalf of an HOA to the board. But there might be situations where they might not want to. So I think it's going to depend on a few factors.
Correct. Yeah, I would agree with that. Anonymous, our HOA records our HOA records board of director meetings, audio and video on Zoom. The recordings are available to every board of director member and probably non-board of director homeowners. Is this allowed?
Let's see, where's that question?
It's anonymous and it's it's got 6 upvotes. And
Okay.
Gary also
Our HOA records board of directors meetings, audio and video, and the recordings are available to every board of director member and probably non-board. Is it allowed? I would say that it's allowed, but it's not a good practice. It's not I would say that if they were my client, I would say I don't think you should be recording these meetings. Like, the homeowners have the right to attend them, but they do not have the right to record them. And if you record them, they're potentially discoverable in litigation. Our add-on, our manager records but destroys the recording after the minutes are prepared. That's a common practice. That the recording is just to help prepare the minutes, and it's not meant to, more often than not, when people record the meetings, it's because they want to use it against the board afterwards, or use it against the management company, or use it in litigation or some things like that. So, I mean, are they allowed to? I mean, I think if they did, state at the beginning of the meeting that it's being recorded, yes, they're allowed to, as long as everybody's aware of that. But I don't think there's good reasons to record them. This, unlike public meetings under the Brown Act, where the legislature specifically said that people have the right to record them. I don't think there is, there's definitely nothing in the Davis-Sterling Act that says that anybody has the right to record these meetings. And I think as a general kind of best practice, it's not a great idea.
Okay, so I think we'll take one more question here, let's see. Bob Sullivan asks, expected privacy, does it include closed doors, including garage doors and covered windows?
Let's see. Expectation. This is Bob. How many upvotes does it have?
Yeah.
How many upvotes does this question have?
Expected privacy, does it include closed doors, including garage doors and covered windows? So if the building has the doors closed and you can't see inside, would that be expected? You wouldn't expect privacy. I mean, you can't see inside, right?
Yeah, I mean, the reasonable expectation of privacy that comes from criminal law, which is, whether the police need to get a warrant for something, right? And then it's been sort of extended to other situations in terms of invasion of privacy. It's where a reasonably sensitive person would or would not expect that they could be seen or heard, right? So if they're within their own home, you have an expectation of privacy there. If you're walking through the common area, not so much. But if a camera or a microphone is picking up something in a place where somebody would normally not be expect to be seen or heard, then they have less of an expectation, I'm sorry, if it's picking up something where they would expect that they could be seen or heard, then they have less of an expectation of privacy. If it's somewhere they wouldn't, then that's less defensible. So, you definitely, if you're going to have anybody installing cameras, you want to say it's only allowed to capture the area directly in front of your home or your door, and not using technology to see into other people's homes or into the common areas.
Okay, well, that's good. I think one comment in the chat, which I thought was kind of interesting and a good one, is how do you know if they've actually if the person recording the minutes actually deleted them? And the answer to that is you really don't unless it's you, right? So that's kind of the bottom line there. Let's go ahead.
I mean, you make it part of your internal policies,
Yeah.
right? And you say, like, this is our policy, is that the secretary can record the meetings, but afterwards they have to delete it. And if they don't, then maybe the board needs to vote to remove that person as secretary because they're not following the board's directives.
Okay, so that's a good question. Appreciate it, and a good one to end on. And I want to say thank you to Stephen Brendel for doing this presentation with us today and helping us understand and navigate this little bit of a blur area of what's privacy and what's not. So thank you so much for tackling that with us. And I want to say thank you to all the ECHO members for coming here today and supporting our ongoing ECHO webinars. For those of you who are not ECHO members, please consider becoming a member of our association. To join, simply go to www.echo-ca.org and click on the membership tab. It's easy to do. For ECHO members, thank you again for supporting us, and please invite your friends, board members, and especially management firms and vendors to join ECHO. A simple invitation is often all it takes to encourage someone to join and support our association. If you would like to become more involved with ECHO, we have a few opportunities for you. Please refer to the slide that Connor's putting up. If you see anything that looks particularly interesting, please send me an email at dzapponi@echo-ca.org. We just did an educational seminar in San Jose, and we had several. I probably had a dozen or half dozen volunteers. It really helps when we have many hands makes light work. And now for our other announcements. This year, ECHO is launching a new educational program focused on HOA board preparedness. The core curriculum is 10 courses and is designed for high quality training and is available to HOA board members. Interested homeowners, actually available to anyone. It's HOA board members, it's designed for them, but also interested homeowners and professionals. If you have someone interested in joining your board and you have maybe you have an apathetic community, you might have them take a look at the courses, and maybe you'll get somebody interested in participating more. Your participation in this program will earn you the Certificate of HOA Board Member Preparedness. The courses will initially be offered live via webinar with 8 of the 10 courses recorded. And if you miss the live program, the course will be offered on demand as a recording, and you can take it there. If you or someone you want, wants to enroll in the certification program, and please send an email to Connor. He'll set you up. His email address is on the screen now. Our 2024 resource. Excuse me.
You're good. Sorry.
Okay. Our 2024 resource panels will continue this fall. This year, kicking off with the Wine Country, North Bay, and San Francisco resource panels on September 10 and 1. We look forward to seeing you there. The Wine Country or the San Francisco panel, we actually have a wine tasting. That's a lot of fun. The other panels are going to be wonderful as well. So look forward to seeing you. Wine Country's in Santa Rosa. The North Bay is in Nevada. ECHO is also planning 2 larger events this year. Once again, thank you to our sponsors for making the educational seminar possible. Thank you to Stephen. And of course, thank you to all of you for attending today and making this a successful event. ECHO appreciates your investment in education to foster a better quality of life in HOA communities.